Welcome back. I'm Don Cleveland, the author of Revitalizing America, A Declaration Against Our Government. And if you'll recall, in the past we've talked about a number of things, but today I'd like to start discussing the three branches of government that were created by the Constitution. But before I do that, let me just recap a little bit on what we talked about before. First, we talked about the horrendous and continuous religious wars carried on in Europe for 100 years before our refugee ancestors fled to be free in the wilderness of North America. The continuation of that religious rivalry and, quite frankly, stupidity and tyranny found its footing in something as silly as finding people and identifying them as witches and bringing them to trial as witches in Salem, Massachusetts. We also looked at the possibility and the reality of what happened in the war against the Catholics in Maryland, a carryover from squabbles of religious and political power in England. We also looked at the European wars and how they spilled over into the new colonies, and the American Indians were used as tools by the French and the British to conduct their warfare against the colonialists at the time. We looked at the development and the play out of the revolutionary struggle to break away from England, including the alluring promises made in the Declaration of Independence. And perhaps, when you look at it, the Declaration of Independence may have been a well-timed propaganda instrument used to recruit militia troops to defend against the largest English invasion fleet that was focusing at the time on Long Island, New York, a battle which the colonies lost, and Washington had to flee in order to stop from being annihilated. We also looked at the broad promises made to all Americans in various written documents used in the founding of our government, and the key follow-up mantras which have become engraved in our minds through continuous repetition in our society. We also looked at the formation of the first government of the United States through the Articles of Confederation in 1781, and of course, its failure. Finally, U.S. Congress, acting under the Articles of Confederation, authorized a constitutional convention to be held in Philadelphia in 1787. The convention, actually presided over by George Washington, threw out the Articles of Confederation, and Washington sent the new Constitution to Congress for adoption by it and the 13 states. It was adopted in 1789 and was what everyone should recognize was a naked constitution because it was devoid of any guarantees of civil or human rights promised so broadly in the Declaration of Independence. We also discussed then the attempt to add 17 amendments to the Constitution by James Madison in 1789 and 1790. But Congress only adopted 10 of these. The other 7 were thrown in the wastepaper basket. They refused to incorporate the Declaration of Independence into our Constitution. We ended up with a Bill of Rights, or the first 10 amendments to the Constitution. These amendments still failed to fulfill the promises made to Americans for guaranteeing life, liberty, and the pursuit of happiness. The 10 amendments were added to the Constitution in 1791. To paraphrase, the Americans didn't have a fully naked Constitution after the Bill of Rights, but we had a partially clothed Constitution. The struggle for human rights and civil rights still lay ahead, even leading to the Civil War in the United States. Now it's time to take a little bit of a deeper look into modern events which not only demonstrate the deficiencies in the Constitution to adequately address the needs for human and civil rights, but deal with the crass offenses against the intent and legal application of the Constitution. Remember, the naked Constitution did only one essential thing. It set up the government's organization. It had 7 articles, and the first 3 described the branches of government. Article 1 created the legislative branch, Congress. Article 2 created the executive branch and all of the executive offices under the presidency. And Article 3 created the judicial branch, or the courts. These branches were established to be equal and are supposed to create a check and balance on each other. But let's start with one of the three branches, or departments, or institutions set up in the naked Constitution. Let's take a look first at the Judicial Department. The Judicial Department is established in Article 3 of the Constitution. Just an ad lib comment here, you may find some of this reading to be dry and boring, but that's why many people don't read the Constitution and don't understand what your rights and duties are under American law. Article 3, Section 1 of the Constitution reads as follows: "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." Who's supposed to establish them? The Congress is supposed to establish the courts in the United States, except the Supreme Court, which is protected in the Constitution. The judges, both of the Supreme and the inferior courts, shall hold office during, not their lifetime, but the Constitution says, good behavior, and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. So, to sort of put this in more common words, this section created the Supreme Court and gives the Congress the power to create inferior courts. Congress did just that. So far, the United States has one Supreme Court, 13 United States Courts of Appeals, and 94 United States District Courts. The language itself, according to some, gives judges of the courts a lifetime tenure. But as stated before, that's not what the Constitution says. The article clearly states that they can hold office during good behavior. So what's a fair definition of good behavior? Congress and the American public need to find a definition that is fair and will not balance on the knife's edge of partisan politics. Going beyond that, of course, the judges' pay cannot be reduced while they're in office. It's important to note that the Constitution doesn't say how many judges are on the Supreme Court or other courts. In fact, the number of justices on the Supreme Court has varied from 5 to 9, changing several times since 1789. So the number of justices is not a holy thing. It's a number set out by Congress at Congress's will. And when you have the Supreme Court only hearing 70 cases out of 7,000 cases coming to it, is 9 the right number? Think about that. Section 2 reads as follows, and stay with me because it's a little bit dry. I apologize for that. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and the treaties made or which shall be made under their authority, and then to all cases affecting ambassadors, other public ministers, and consuls, then to all cases of admiralty and maritime jurisdiction, to controversies which the United States shall be a party, to controversies between 2 or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming land under grants from different states, and between a state or citizens thereof and foreign states, citizens or subjects. In all cases, get this now, in all cases affecting ambassadors, other public ministries, and councils, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Original jurisdiction is not appellate jurisdiction. It doesn't have to come to them on an appeal. They can take up the case on their own. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact. Such exceptions and under such regulations as Congress shall make. Notice the control of the Congress again over how the Supreme Court operates. The trial of all crimes, except in cases of impeachment, shall be by jury. This is the right to trial by jury in criminal offenses, obviously, and such trial shall be held in the state where the said crime shall have been committed, but when not committed within any state, the trial shall be at such place or places as Congress may by law direct. This section of the Judicial Department's article sets out the jurisdiction of the Supreme Court and the inferior courts created by Congress. In other words, what kinds of cases can the federal courts accept and litigate? It's obvious they can judge cases involving federal and international law, also disputes between states and citizens of different states. The Supreme Court doesn't just hear appeals. As pointed out earlier, it has original jurisdiction, so they can try cases from the very beginning, but only if they relate to ambassadors, ministers, and consuls, or a state. Courts have appeal authority, as does the Supreme Court. So anything else other than that in which they have original jurisdiction must come to them on an appeal. But the section also gives Congress the power to make the regulation under which the courts operate. The rules of civil procedure, the rules of criminal procedure are the regulations of the courts. These regulations also allow the adversary system to exist. This is the basic system we use in our courts throughout the United States. Some of the bad parts about the application of this system is that it allows a wealthy person to hire the best lawyers and provide the best defense or offense, and at the same time the average citizen has to hope that a public defender will put up an adequate defense if they're accused of crime. In general, Congress can do anything they want with the Supreme Court except abolish it or reduce their pay while they're in office. Also, it's interesting that the last sentence of that section gives a very strong hint that the application of the laws of the United States extend to all citizens and legal residents anywhere in the world. So if any U.S. citizen or resident violates a law of the United States while in England, that person can be tried by the U.S. once the U.S. takes jurisdiction or control over the person. Very strong evidence of this exists in the Uniform Code of Military Justice, which applies to members of the United States military anywhere in the world. Additionally, think about the miniature size of the United States in 1789. Everything west of the 13 states comprising the United States belonged to France, England, Spain, Mexico, or Russia. That meant as soon as anyone went west from the western border of Pennsylvania, they were in a foreign country. Section 3 of Article 3 of the Constitution provides the only type of constitutional crime that exists at this point in time. Section 3 defines the crime of treason. Treason against the United States shall consist in levying war against them, the many states, or adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or from a confession in open court. The Congress shall have power to declare the punishment. Notice again how Congress enters into the judicial system. They shall have the power to declare the punishment for treason, but no attainder, remember the Bill of Attainder, of treason, shall work corruption of blood or forfeiture except during the life of the person attainted. So, this section, as I indicated, really doesn't deal with the structure of the courts, but instead defines the only constitutional crime in the naked Constitution: treason. Treason is defined in a very narrow sense. It shall consist only in levying war. The Constitution falls short of providing other classes of constitutional crimes, especially crimes that violate human and civil rights? And what about the breaches of duty by those who took an oath to uphold and support the Constitution? We'll deal with more of those issues in the future. And for more information on the promises made and broken, you can visit my website at revitalizeamericanow.org, or better yet, you can buy a copy of the book on Revitalizing America from either my website or from Amazon.com. We'll speak again. Thank you.